Hi everyone, you're watching the virtual Amicus and I'm Jay Lodha. Well, today's topic for discussion would be on Insolvency Bankruptcy Code, its challenges and opportunities ahead. And joining me on the virtual Amicus is a highly renowned, respected, and a very distinguished both solicitor and an advocate. She's in conversation with Miss Sugyata Choudhary. And just to give you all a brief introduction about our amicus for today's session, she's an associate partner at Dhaval Vasanji and Associates. She's also a member of fellow of the Chartered Institute of Arbitrators. She's a solicitor as well as a lawyer practicing in Bombay. She's a seasoned solicitor with over 11 years of expertise in dispute resolution, specializing in strategic recovery of stressed assets and NPAs for finance companies. With a strong focus on enforcement of security, restructuring, and litigation, she advises lenders and asset reconstruction companies on maximizing recoveries. Her practice also encompasses representing clients in high stake commercial litigations and arbitrations, primarily in construction, real estate, and corporate insolvency matters. So, thank you so much, Sugyata, for readily saying yes, for agreeing
Thank
to
you.
this session on my channel. Anything that you wish to say about my channel before we quickly start with our much anticipated Q&A segment?
Thank you so much, Jay, for having me over. I must say the virtual amicus is a it's a great initiative. There's so much that I've learned while I've gone through the videos of so many renowned people from the legal industry uh, through your channel. And I'm sure, I hope all of your viewers also must be gaining so much insight into not just the practical sides, but also the like a lot of things which are not so widely spoken about in the public domain. We get to see that on your channel. So thank you so much. It's a great initiative. Kudos to that. And thank you so much for having me today.
Well, grateful for all the kind words. Let's quickly start with our Q&A segment. Well, this is one topic that has never been covered, and we'll be talking about IBC and its impact in the real estate sector. So, question number one coming your way. Could you please explain the purpose and objective of Insolvency Bankruptcy Code in a nutshell to all the viewers?
So, in a nutshell, the Insolvency and Bankruptcy Code, so if you notice, this is called a code and not an act. This was supposed to be a welfare legislation, which was brought about to sort of bring about a revolution in the within the corporate world. If the IBC actually came in early in 2016, and the objective of this, so IBC is mainly divided into the two kinds of insolvencies, which is corporate insolvencies and personal insolvencies. Although personal insolvencies have not been a lot of that part has not been notified yet by the government. So at the moment in practice, the corporate insolvencies, which is the insolvency of companies, limited liability partnerships, and basically corporate persons that is actually in force right now. The objective of this was really to transform a sick company into a fully functional working company. So earlier there was a Sick Industrial Companies Act. I don't know if many are aware, but earlier there was a Sick Industrial Companies Act, and the Companies Act itself had a mechanism for the winding up of companies which are unable to pay back their debts. The Insolvency Bankruptcy Code really came about as like a reform resolution that basically enabled corporates or companies to restructure their entire debts. And wherever they were under a lot of debt, the objective was to, in a way, repair these companies. So, in simple terms, it was when these companies became loaded with a lot of debt and they became very overburdened, and they had to be resolved. This is an act which enables these companies to be resolved and to resolve their debts and to make it functional and to bring them back on their feet. So that is the primary objective of the IBC, if you ask me.
Very well. Now, going ahead with our next question, please explain when and under what circumstances is the CIRP process initiated?
So, the CIRP, which is Corporate Insolvency Resolution Process, that is really, so there are three main sections in the Act which talk about the initiation of a CIRP, which is Section 7, 8, and 9. Sorry, and 10 also. So, CIRP generally is initiated when a corporate, there are two kinds of creditors in IBC, the operational creditors and what we call as financial creditors. So, financial creditors, so any creditor as such can initiate a CIRP against a corporate person when they become unable to pay their debt. So, there are certain threshold limits, so, and that differs for different creditors. So, let's talk first about operational creditors. So, for operational creditors are, your daily, your vendors and with people with whom the companies have operational contracts. So, for example, if there is a company in the business of real estate, and that company, they engage a lot of vendors for getting raw materials or for construction, etc. So they raise bills and invoices on these companies. So when these become unpaid for a long time, so these vendors, they become operational creditors. That is, I mean, I'm just giving it to you in a like a very simple language. And financial creditors, on the other hand, are those creditors which have which generally where where there's an interest component running, where what we call as a time value for money. So they could be banks, financial institutions. So they are called financial creditors. And they are more larger creditors typically, like banks and financial, when they typically lend money to the company for an interest or for some sort of financial premium, that they fall into the category of financial creditors. So both these type of creditors can initiate a CIRP against a company. And for operational, so the threshold limit for that is of course 1 crore. So the debt has to be over 1 crore. Only then a CIRP can be initiated against the company. So and Section 10 is voluntary insolvency. So even the company themselves can, like how it was erstwhile in winding up, that when a company could not pay its debts, they could initiate a voluntary winding up. So similarly, even in the IBC, there is a concept of a voluntary CIRP under Section 10, where a company can voluntarily also initiate CIRP. So, so these are the instances where CIRP can be initiated against the company.
Now that we've discussed CIRP process and when it is and in what circumstances it initiated, can you please explain what moratorium period is as defined and explained under Section 14 of the Insolvency and Bankruptcy Code?
Yeah. So basically, when one of the where there is an application filed, so the forum where the CIRP application is filed, what we typically call as a petition for initiating insolvency, it is the NCLT, which is the National Company Law Tribunal, and typically the National Law Company Tribunal of the having the jurisdiction over the registered office of that company, where against which you want to initiate CIRP. So typically, when an application is filed, or a petition is filed under Section 7, Section 9, or 10 to initiate CIRP, the NCLT either admits the petition or it rejects the petition. So in cases where it admits the petition, there is something called as a moratorium period, which begins from the date of the admission. So this moratorium, the concept comes under Section 14 of the IBC, and this really runs from the date of admission. So essentially, what happens is that during the moratorium period, there are certain restrictions that there are on initiating any actions against, or any suits or any petitions or anything of that sort. So also there are certain licenses or certain terminations, etc., that cannot happen and even other debt enforcement cannot take place during this moratorium period. And so typically, after admission of an insolvency petition, there is a IRP that's appointed, who's an interim resolution professional. And the resolution professional, he's basically a professional who is, qualified under the IBI rules, etc. And he takes over the management of the company. And what he does is that because there is a moratorium period, he takes over he forms the committee of creditors, etc. Because obviously these concepts are a little more technical and detailed, which we can talk about later. But to answer your question, the moratorium, it is defined and it is explained under Section 14 of the IBC. And there are a lot of when moratorium is concerned, of course, there's a lot of jurisprudence around it also, that which where there are many questions practically which have arisen, that during a moratorium, what kind of actions can be taken, what kind of actions cannot be taken, and there are a number of judgments on this. But to put it very simply, it's basically this is the period where no actions can be taken against the company.
Very well. Going ahead with our next question, how significantly has the IBC impacted the real estate sector? If you could please elaborate for us.
Yeah, so very interestingly, about 20 in 2023, around 21% of the total CIRPs were really real estate companies. This sector really contributes very significantly to this whole ecosystem of the CIRP. So because a lot of, especially what happened after COVID, was a lot of companies, real estate companies, were finding it hard to continue with their constructions, and they were facing significant liabilities and costs, etc., which they could not meet. And a lot of these companies uh, have gone into insolvency. Especially, there was one amendment also which came into the IBC, especially for the real estate sector, which made flat allottees also financial creditors. So even the allottees in a real estate project, like even there's a threshold of about 1/10 of them. They can even get together and they will qualify as a financial creditor under the IBC. So this was a significant amendment, that there was the first time that any one particular sector has contributed to an amendment in a as such. So it was very so definitely real estate sector has it has faced it's a very dynamic sector, and it has got a lot of it's gone through a lot of changes in so many years. So in the IBC, they have the main thing that I think we've seen is that the judgments, the jurisprudence that has taken place. Even the concept of project-wise CIRP is something which is very unique to the real estate sector. That there was basically there was an amendment that in the regulations, that that a project wise resolution can be achieved by the RP, which means that the company can have various projects, so every project can be a separate CIRP. So these are some very interesting things which are very unique to the real estate sector and IBC.
Now, going ahead with our next question, what are the gray areas in IBC according to you? And what concrete steps can be taken in that direction according to you?
Yeah, so there are many gray areas actually. To start with, the gray area surrounding, for example, withdrawal of a resolution plan. Currently, there is no provision as such in CIRP which allows the successful resolution applicant to withdraw the resolution plan once it has been approved by the COC. And that is also something which contributes to the lot of quandaries around this act. Another interesting gray area is when it comes to the moratorium itself. Like there are a lot of conflicting laws, in the sense that laws like the welfare legislations, like the Slum Act and Hada, etc. So typically, what happens is that once the CIRP is initiated against the company, if the corporate debtor is in possession of some land or some or land, or it has as an asset, that land is also taken as a part of the assets of the corporate debtor, and then the moratorium will apply to that. So there can be no action taken against that land. So there have been various judgments of the Bombay High Court and the Supreme Court and CLAT, which have held time and again that that there has that what exactly constitutes this assets of a corporate debtor. So a recent judgment of Victory Iron Works also talks about now it has settled the law to say that development rights are also assets of the corporate debtor. Prior to this judgment, there was a lot of gray area surrounding that whether development rights of coming arising out of a land would that qualify as an asset of the corporate debtor. So these things are, gray areas, but also another gray area is, many times when the companies are within insolvency or there is a moratorium going on, RERA and other authorities like that, they continue taking action against the company. And they are not really bothered about whether the company is in CIRP or not. So to what extent that this does this bind those authorities? That is still a gray area. I mean, nobody talks about when a company is in CIRP, a RERA action can lie or not, or whether the slum rehabilitation authority can terminate the license of the company or not, the LOI, etc. So these things are still in gray area for in the IBC.
Now, you specialize in strategic recovery of stressed assets and NPAs for finance companies. Could you please elaborate that for us in simple terms?
Yeah, so what I generally do is that a lot of companies, a lot of we work with a lot of finance companies and ARCs which have high value debts which have turned into NPAs. And these NPAs are generally secured by way of projects and real estate projects, and the security that is really given for these debts are usually high value projects, entire projects of companies which are under various phases of construction, or they could be it could be security from a guarantee to a pledge of shares, or it could be any sort of security. So typically what I do is we analyze first as to what would be the most ideal way to enforce this security. What would be the best way to enforce this security to enable to get the maximum recovery from these NPAs, and then we implement that strategy. And obviously that includes, like, it could be it really depends on a lot of things, but the it's like a three-pronged approach. Like, the first we analyze, then we appropriate what exactly to do, and then we implement that strategy. So it is quite like a mix of restructuring and litigation, and also to analyze which litigation and which forum and which court would be the best to uh, sort of recover these stressed assets. So that is in
And
a nutshell.
you also advise lenders and reconstruction companies on maximizing recoveries. Could you please elaborate that for all
Yes.
our viewers?
Yeah, so that is linked to what I just said about what I do. So the maximization of recoveries is a part of
Yes.
our analyzation and the strategy what we adopt to recover the debt. So that usually is a combination of various actions like SARFACE, even the DRT and filing an OA, or it could be, filing some suit or some action in the high court to get where we think that there is a chance of higher recovery from
Right.
there. So, and it also includes IBC, of course,
Hmm.
arbitrations, if the contracts have an arbitration clause. So it's like there are a lot of moving parts, and the primary step is to analyze and to strategize it, and then to implement it.
To sum it all up in a nutshell, devising a legal strategy in such a way so as to ensure maximum recovery, for the asset reconstruction company that you're paying for or you're advising.
That's right. That's right.
So now that we've discussed your area of specialization and who all are you advising and what is IBC in short, in a nutshell, moratorium period, and when is the
Yeah.
CRP proceeding initiated. Now tell me one thing: do you have any mentor? And if at all you have one, then who was your mentor in this field or in this area of specialized field that you're in?
Yeah, so I was very lucky to have my first boss who I worked with, Sriraj Dhruv, his name is, in Dhruv and Company. It was I started with a very small firm. I started with a mid-size. It was a small, typical old school solicitor firm where I had signed my articles, and I did my 3-year articleship, and that's where I started. And then I continued working there for a couple of more years. So he was himself a gold medalist solicitor at the time, and I would say I was pretty lucky to get a training under, in that old school fashion where we would, go through commentaries, and we would be dictating drafts from the very start. So very early in my career, I actually started, learned dictating drafts from him, because that was a very typical old school solicitor way of doing. So I would definitely, I think a large part of my practice today and what I do at my work, I have learned it all from him. And I was very lucky to have been, from the very beginning, I was pushed into a lot of, high court litigation, which was both complex as well as very high stake at the time. So although the firm was smaller, but the work that we were doing was only relating to high court and typically real estate related litigations. So I would say that I was quite lucky to have a mentor very early in my career, and I definitely consider him as my mentor. And he really guided me and gave me a lot of direction in my career.
Wonderful. Now, any memorable experiences or breakthroughs that you wish to share from college or at workplace that, which ultimately proved to be a turning point in your career?
Yeah, so couple of stories. Very early, so I was a part of this college. So I was in GLC, Government Law College, and we had something called the Delhi Study Tour in that college, where we had to first write an essay, and then some of us were chosen to go and meet some dignitaries in Delhi, where we were, given to meet, meetings, sitting judges or parliamentarians and MPs and ministers at that point of time. So I was very lucky to have gotten chosen for that in 2014 or 2013 actually. 13 I had gone for this, and I do remember that. So I think that was a major breakthrough, which gave me a lot of exposure to how lawmaking works. I think my first visit to the parliament was very interesting to see how the law is actually made rather than just seeing the practice side of it. So in college, that was definitely a big turning point for me. At the same time, I had also participated in a moot court, in a national moot court in Kerala, where we had represented GLC in Trishur. It was a GLC Trishur. Although we made it, I think, till the semi-finals, but that gave me a very, since that was my first national moot court, that gave me a lot of it was a very mind-opening experience for me, and I definitely do recommend, every student to do at least one moot court. I know there are a lot of us who are not very comfortable with doing moot courts, and that's totally fine. But just having that experience, for one, that really I think goes a long way, and that did help me also in many ways. And other than that, of course, I think signing articles for solicitor exam, that was a big turning point in my life, and actually clearing the exam in one go, that was also like a quite a feat for me, because I had a continuous streak of 3 months of just studying, and it was thing, but yeah, I would consider that as a breaking through point for me, because that really really made me realize how much I don't know, and it has actually set the base on the tone for me to understand legal practice more than just practice it, but to understand where and how the law works. I think the exam gave me a really, really wide view to that. So I just consider that as not one of them.
The solicitor's exam is indeed a very, very hard exam. And, I salute you
Mm.
for clearing it in your maiden attempt. And by the way, even I was part of the 2008 Delhi Sky Tour delegation.
Oh, okay. Oh,
And,
wonderful.
a very important trip and a turning point in all our law school.
I guess so. Yes, yes, and it just teaches you so much, and it brings you. I think that,
The
and that
confidence that it had instilled in us. I mean, the
yes,
confidence of
absolutely,
how to interact with
absolutely
dignitaries and how to,
correct.
and even camaraderie for that matter. When you're traveling in a group, you learn so much from each other. And
Definitely, definitely. It was definitely very like, and especially to hear even experiences from, like we had met Falina Riman at the time, and then we had also met Rahul Gandhi, and at that time the Congress government was in power. So, it was definitely very, you know, it was an experience to remember for sure. Yeah.
wonderful. And lastly, what would be your piece of advice to all the young lawyers, law students who wish to build a successful career
Yeah.
like you have in this field? Any particular internship or course or book that you wish to recommend to all of them?
I think I think my one advice would definitely be to really so law is it's a very vast profession, right? It's got like so many practice areas and so much of depth in everything. So I think my one of my major advice would be to really find your focus um, a little when you can to be able to focus on the kind of law that you like to practice, or to find your passion when it comes to a particular practice area. And that is something that definitely goes a long way, and that can really shape your life in a very uh, different way. And as far as courses and books and all are concerned, I have always been a believer of like bare act is king. I think for me, I have not. So after the solicitor's exam, I actually did take the CIRB course. So I did the accelerated route to CIRB. So now I'm a qualified fellow of the CIRB, which is the Chartered Institute of Arbitrators. So essentially, that is a course for working professionals to attain accreditation in the Chartered Institute, which can give you, it's like an international recognition to the fact that you're an arbitration professional. As far as working life is concerned, anybody who's interested in in alternate dispute resolution or ADR or is the side of the law, then I mean CIRB has some really good courses, so I would definitely recommend. But as far as modern college and earlier, like early life or college life is concerned, I would just my simple advice would be just read your Bear Act very well. I mean that's my one single thing that I believe in.
Well, thank you so much, Sugyata, for taking out time for doing this incredible session for us. Well, it was a phenomenal session. We've learned so much from you, and hope all our viewers who are watching this, young law students, lawyers, are going to immensely benefit from this session, IBC, and its impact on the real estate, the challenges, and the road ahead. To all of you who are watching this, our email is mentioned on the channel. In case if you still have any queries, feel free to write to us on the email mentioned, and we'll be more than happy to forward the same to our Amicus for today's session. Anything that you wish to say now that we are wrapping this session as parting words before we wrap this up?
Thank you so much for having me over. It was a lot of fun, and it was great to come that I could come and share these things with your audience. I hope that it could be of some utility to everyone who is watching. Thank you.
Thank you once again. It's goodbye for now.
Thank you.